So how are retirement accounts divided in a divorce case? So you're getting divorced and there's a retirement account. You know, one example would be you have a 401k, you have what's known as a defined contribution plan. How's that going to work? Is your wife or your spouse going to get half of that account in the divorce case? So here's how this would look. You know, let's say you're in a 20-year marriage. That's a good example to use. You figure if you're a 20-year marriage and you've been working somewhere less than 20 years, then that means that the entire 401k account was earned during the marriage. So let's go with that example as a starting point. So if that's the case and you're dividing things up in a divorce, then yeah, your spouse has a right to half of that 401k account. Their name's not on it, they didn't earn the money, but the way Michigan law reads on that, it's a marital asset. You earned it during the marriage, you put the money in there during the marriage, and the account's in your name, but your wife is gonna have a right to half of that account. So then how do you go about doing that? Well, number one, you know, if your wife has a 401k of equal value, then of course you're good, right? You'd keep your account, your wife would keep her account, and that's how that would go. But let's say this is the only asset or primarily the only asset you have, or maybe there's a house and this is your 401k and that's about it. If that's the case, then your wife has a right, your wife or your spouse has a right to half of this 401k account. So then how do you make that happen? Well, so what you would do then is you do a court order to split the account. If there's no other offsets, if there's no way to like give you the 401k and give your wife an account equal to approximately 100,000 pre-tax dollars, because the 100,000 is pre-tax. But if there's no other way to make that happen, and you need to actually divide this account to get your wife half the value of this asset, get your spouse half the value of the asset, you can do that. You do a court order. You do what's called a QDRO, which is an acronym for Qualified Domestic Relations Order. So you would do a court order based on an agreement in your property settlement in your divorce case, and the court order would assign half of the 401k account to your wife and half of it to you. So what that would mean then is your wife ends up with an IRA worth $50,000 and you keep the other $50,000 if it was $100,000 total, and that's how that would look. Now, when we say there's a 20-year marriage, so what is that example based on? Well, there's no minimum number of years. So you could be married 5 years and be in a place where you're having to divide your 401k or retirement account with your spouse. There's no like minimum. It could be 4 years, it could be 2 years, it could be 20 years, whatever, anywhere in between. There's no minimum. You know, there's this rule out there that I think people hear about, or there's not a rule, but there's a myth out there that you have to be married more than 10 years to have a right to division of property, to have a right to somebody's assets in a divorce case. That's not true. That's just not the case. It's not the case in Michigan. I don't think it's the case in any state that I've run across. The 10-year rule comes from Social Security benefits. So this idea of 10 years would be, if I'm married more than 10 years, I could make a claim for Social Security retirement, even though I never paid any credits in. So let's say I never worked and I'm married to somebody who pays into Social Security, and I'm married for more than 10 years. When I retire, I could claim Social Security benefits, even though I never paid any benefits into the system, because I was married to that person and I qualify for retirement under the Social Security system as their spouse. The money doesn't come out of their money, I just get whatever number it is. So that's the idea with the 10-year rule. It doesn't apply to retirement accounts or division of assets or have anything to do with any of those things. But so that's a general idea. If they're dividing up retirement accounts, that's what that looks like. Now, if you have a pension, which is, you know, there's getting to be fewer and fewer of those out there. Employers are doing away with providing pensions or what are called defined benefit plans. But if you did have such a thing, that also is dividable in a divorce case, and your spouse would have a right to half of that. Now, they don't get that money now. They would have no way to do that, but they would do a court order, again, a quadro usually, or sometimes it's EDRO. So it's either QDRO, Qualified Domestic Relations Order, or EDRO, Eligible Domestic Relations Order. So this court order gets entered by agreement. You sign it, you have it entered with the court. It's in compliance with ERISA, which is the federal rules on pre-tax money and retirement plans and how all that works. You would do a court order to divide this pension, this defined benefit plan, and basically they would set your spouse, ex-spouse, they get set up in the system as if they had been an employee that worked there. So if you have 20 years of service and you've been married more than 20 years, so the whole pension is from during the marriage, the whole pension is what you'd call marital property, then your wife has a right to half of that pension in the divorce case, and she'd have a court order that would give that to her. She can't draw the money now. She would either be able to draw the money, number one, when you're eligible to receive the money, or number two, when whoever is eligible based on what the plan says. So you get into I don't want to get way in the weeds on retirement and pensions, but there's two different approaches with dividing pension plans, defined benefit plans. There's a shared interest approach, and a separate interest approach. But the short answer is that person would be eligible to draw the pension depending on what the rules are in the pension plan. Sometimes that means they have to wait till you start drawing your share, or it may mean that they just have to wait until an employee is eligible based on age to start drawing a pension. So that's some ideas on what gets divided in retirement accounts with divorce cases and how all that looks. Now, going back to the 401k example for a minute, if we're talking about when does that person receive the money, when does your ex-spouse receive the money from the retirement account? If we're dividing a 401k, when do they get the money? Can they get the money now? I mean, they can. We're going to move the money out by court order and put it into an IRA. Are they going to want to take cash? They could do that. If we know that that's the plan, then we can set it up the right way through the divorce case and avoid the 10% penalty. So, in other words, assuming this person is less than 59 and a half years old, they can't start drawing on that retirement money without paying a penalty. So there's a 10% penalty. So if I'm less than 59 and a half years old and I want to start drawing money out of a 401k, whether it was mine or it was one that I got from a spouse in a divorce, either way, I can't draw that money without paying a 10% penalty. I also have to pay taxes on it, but that's always true. There's no age at which you can draw retirement funds out of a defined contribution plan, a 401k type account. No way to draw that money out at any age without paying taxes. You always have to pay the taxes, but the 10% penalty is definitely in place. So if you know that you're getting divorced and you want to take that money, like let's say you're going to take your half of this retirement account and use it for a down payment on a house, you could do that. We'd want to avoid the 10% penalty. There's a way to do that through the divorce case. Not worth really getting into explaining in this video. You talk to your divorce attorney about that plan. But if the plan is to draw the money and take it as cash, you could do that, avoid the 10% penalty, and in the end, the ex-spouse would have their share of the money from the plan, and the person who was the one that worked there and earned the money, they would keep their half. So that's kind of what that's going to look like. Now, in this 401k example, does the spouse, does your wife get half of the employer matching funds? Like, for example, do they get half of vested? Do they get half of unvested? Because some people have stock plans and they have vesting and vesting rules on their 401k. So, I mean, the short answer is, basically divorce courts are what you would call a court of equity. They're supposed to be doing what's fair, what makes sense, what's reasonable. So the wife has a right to half of this plan, whether that's vested, unvested, employer provided, whatever it might be. In theory, they have a right to half of all of it. So they definitely have a right to employer provided dollars just as much as they have a right to the dollars that you put in there. All of it you're entitled to. They have a right to half of whatever it is that you're entitled to. So I think that's important to be aware of too. But that gives you some ideas on retirement accounts and how they work and who gets what and what's the number of years before it's eligible and what money's eligible and the whole kind of wizarding world here of retirement accounts in divorce.